Welcome back to the LawNewz Network, everybody. The jury is being sent out of the room in the Gasper case in Cleveland, Ohio. They're going to be back to hear closing arguments, I believe, and deliberate at 11:30 Monday morning. In the meantime, they've called a 10-minute break now, and I'm really actually curious to see how the motions to dismiss go at this point, because the state has rested its case. And I'm personally not sure that the state's got this one in the bag. I think there are a lot of questions still on the table here as to exactly whether or not the methadone caused an impairment, and it just right down through a whole list of other factual issues. So while we wait for this break to come back, I want to bring Ken Belkin and Julie Rendelman into the conversation. They are joining us here on the LawNewz Network. Yet again, many of you who watch regularly know them both. So look, one thing I want to bring up right out of the gate that just infuriates me about this case is how many times the state has issued a different speed that they believe the defendant was going. Originally, it was 78 miles an hour when he was arrested, and that's what's been reported over and over again in the Cleveland area. Then it was 65 to 70, and then today it was 62 to 65. Well, it's a 60 mile an hour speed limit, and I don't know, I mean, 2 miles an hour over, based on the skid marks, 5 miles an hour over, like that's excusable. That is not, you know, an element of reckless driving, which is one of the charges. Julie, you're agreeing with me at a minimum. Ken, I at least hope you are.
Any facial. No, I am agreeing. I mean, look, if he's going 78, that's a different story. That could be construed as reckless. You're going nearly 20 miles above the speed limit.
But I think, you know, one of the things you're saying is that how annoyed you are by it. And here's the thing. Cases fall apart, and the only difference here versus another case is that this is being televised. So we have cases all the time where we bring murder cases against individuals, and the individual gets on the stand and doesn't identify the person. And so here you have a case where it's kind of falling apart, and we're all watching it happen.
Yeah, call that prosecutorial overreach.
Something like that, you know. But even, it's like, look, if you're the state and you've got the burden, get your facts straight. You know, I mean, that's just my look at it. But we're going to switch over to the Segura trial because there's testimony still going on live there. We're going to continue to monitor the Gasper case, but for now we'll bring you back to the Segura case in Florida. That's a defendant facing 4 counts of murder, first-degree murder. It's a capital murder case with a death penalty. Welcome back yet again, everybody, to the LawNewz Network. Aaron Keller here along with you for about the next hour of analysis, along with Ken Belkin and Julie Rendelman in-house to sort of tear apart this Segura case. I've been talking about Michelle Carter and the Gasper case for a couple of days, but Julie, you're really getting into the Segura case.
Love this case. There's just so much to it. What would you like to know?
You tell me. I know they've got this weird DNA on the scene that they can't quite figure out. I know that you've got this other guy who was in prison who claims, oh yeah, I put a hit out, and then the judge said, I don't buy this, but then they're going to have to let the testimony.
The evidence in. Yeah, no. So you have a guy who's basically had a girlfriend who had a child with her. You know, there seems to be certain evidence that ties him to it, i.e. there's cell phone records from a second phone that indicates that he was at least in the vicinity when the crime happened. It seems that he was calling her all day, but it seems that the phone was not being called between him and her during the time where the death apparently happened. He also apparently, again, some of this has not come in as evidence, but there seems to be some evidence from witnesses who will say that shortly before the death, he had asked or purchased a .32 caliber gun. And the last piece of evidence that seems to be kind of always interesting to a former prosecutor is that there seems to be an inmate of which he confessed to killing these individuals. And so that seems to be what the prosecution has, but there's a whole lot of evidence that seems to indicate that possibly someone else or other people were involved in this death and not him.
Well, you put it in an interesting way. I mean, it could be someone else or other people. You know, and there's the thing that was said to me years ago by a prosecutor that there are always people behind bars who are pretty much willing to say whatever they can say to try to get out. Sure. So why would somebody behind bars just turn around and confess and say, oh yeah, I am involved in a drug cartel and I'm calling for the hit on this person?
I mean, come on.
Other than to try to get someone to, let me out of jail on my other crime or something.
Jailhouse snitch has about as much credibility as my cat in a matter of this nature.
Your cat
You
must
can't
be
li-
really
He's subject
evil,
to
Ken.
such impeachability on the stand. He has such motive to fabricate evidence. Now, backing up to your DNA evidence, look, as I've said to you before, and look, you guys probably have DNA from me on you from the last time we were at this table together. It's not necessarily indicative of much.
Well,
The
actually-
case
Makes me wanna
seems to
take a
be
shower,
purely
you know.
circumstantial.
But remember, we're talking about two snitches. So the first snitch is the snitch that apparently the defendant confessed to. That person, I agree with you, has the most to gain, because usually when someone's snitching on someone else confessing, the reason they're doing it is they're trying to curry favor in some way with either their case or future cases. You have a twist here, because now you have a second individual who's not saying the defendant confessed to me, he's saying, I did it. And not only is he saying I did it, but apparently there's evidence that he did have, meaning the person who's incarcerated who's saying a drug deal gone bad, he did have some type of relationship with the victim. And so there seems to be some substance to what he's talking about. Two, when we talk about DNA, you're right. DNA can be left in any location. There's a difference here. The DNA that they're finding that is not the defendant's is under her fingernails, which she clearly made a struggle because some of her fingernails are broken.
Or-
Two, there's also on what appears to be a shovel that was used apparently in the beating of one of the individuals in the house. So those things are, you're right, but when someone starts admitting to something and then you have other drug dealers' DNA and you don't have the person who's on trial, you got a jury who's going to start to wonder, well, what the heck's really going on here?
Well, hold on. DNA under the fingernail doesn't necessarily mean a struggle. There would have to be other signs of a struggle. I mean, I could lightly
Well, there
raise your
were.
arm
I mean,
and
there's
get some
evidence
DNA under my
that she,
fingernail.
the cause of death
but I will
was
say-
a beating to the head. It wasn't the gunshot. So, okay, well, there's that sign of a struggle.
Well,
Yeah,
no, there was
and I
also
will-
evidence that her fingernails were broken, and signs of a fingernail being broken with DNA under the nails is an indication of a struggle. It's also potentially because it seems to be such a mess in there that it may have been more than one person. And if there's more than one person, that looks more like a hit than it does of some ex-boyfriend who's not happy with her.
Yeah, well, I agree. The person confessing, that's a big problem for the prosecution's case, because no one is going to put, look, jailhouse snitch certainly has intent to lie. It could be helpful in his case, but someone confessing, I mean, they're really putting themselves under the gun.
The problem, but the problem they have with the person who's now confessing is how are they getting it in without him getting on the stand and admitting it? That's I just don't know. I don't know the specifics as to whether he's admitted
Well,
it.
it's a hearsay statement again. It's interesting.
Oh, I think there was a hearing beforehand in which he admitted to it on the stand, which is bizarre. I've never seen anything like that. So I don't know if they'll be able to, if he's not willing to testify now, if they'll be able to get that in on their defense case. I don't, it'll depend on what the judge's ruling is.
Yeah, we will have to see. Well, let's listen to some of the previous testimony in this case. We've got a clip queued up from the Latent Print Examiner. Let's listen to that.
The home.
And those were found in the areas you just told us about?
Yes, ma'am.
Okay, except for the master bath that didn't have any latents of any kind.
No, ma'am.
Now, those latent prints that were found, could those be from anyone who has ever touched those surfaces?
Yes, ma'am.
Does a latent print tell you when a person touched a surface?
No, it doesn't.
Of those 9 total latent prints that you found, how many were of evidentiary value?
There were 2 of the latent lift cards that I collected that were determined to be of value for comparison.
Okay, and I think you had told us this yesterday, but when I say a value, I mean that there's enough of a print to even be able to compare it to something else, correct?
Yes, ma'am.
Now, one you told us about yesterday, that was from the hallway bathroom tub, and you said it was a match for Brandy Peters.
It was identified to Brandy Peters.
Okay.
Yes.
And then, where was the other latent print of value found?
The other one was from the interior garage entry doorknob.
Right, and I want to show you what I've marked as state 70 UUU. Showing you the print council. You recognize 70 UUU?
Yes, ma'am.
What is it?
It's a picture of the garage door and the garage.
Is it true and accurate depiction of the garage door from that angle?
Yes, ma'am.
At this time of the 70 UUU in that evidence?
Any objection? There you go.
Permission to publish?
But I thought that 70A through 3T were admitted, were they not? They were not, okay,
So we had, that was a couple of things that we
okay,
had brought forward.
okay. So 70U at this point in time,
Yes, sir.
they'll be admitted?
All right, so working our way out of the house, I know we've already seen this door in our last set of photos from, I guess, inside the kitchen. You could see the corner of the door. But what do we see in this photo?
It's the garage of the home.
Okay, so this would kind of show that entry door in the garage from both
Okay.
angles, interior and exterior.
Yes.
Is this the door that you gathered that latent print from?
It is.
Okay, and where on the door did you find the latent print?
It was the interior doorknob
The interior doorknob, meaning the doorknob that's
on the inside of the
kitchen?
home. Yes.
Okay. And were you the analyst that performed a comparison of this fingerprint?
No, ma'am.
Okay. All right, moving on from the scene of the home. Did you also attend the autopsies at the medical examiner office on Sunday, November 21st?
I did attend the autopsy of Brandy Peters.
Okay, so the day after you started processing the crime scene, you went to the medical examiner's office for Miss Peters's autopsy
Autopsy.
only?
Yes,
Okay.
ma'am.
Commissioner Approach?
No?
At the autopsy of Miss Peters, did you collect a buccal swab of Miss Peters?
I did.
And what is a buccal swab?
It's a swab that we take the same with the same Q-tip. It's the inside cheek area of your mouth. It's for DNA purposes.
And when you say for DNA purposes, you mean so that a DNA analyst can compare that swab to other swabs that you've taken?
Yes, ma'am.
And you said you take it from the inside of the mouth?
We just swab the cheek area.
Is that the
On the
same
inside.
type of swab that you use on blood spatter and things inside the home?
The way that we collect it is similar. Yes, ma'am.
Okay. I want to turn your attention to State's Exhibit 111. Do you recognize 111?
I do.
And what is 111?
This is the buccal swab that I collected of Brandy Peters at the morgue.
Does it appear to be in the same or substantially the same condition as when you impounded it?
It does.
This time I would move 111 into evidence.
Any objection? There. 111 will be admitted.
Right. If you could put that notebook aside or move on to the next one, I want to ask you about the other things that you collected from Ms. Peters.
Okay.
So that's one of the forensics examiners on the stand talking about the processes of gathering all the evidence that, Julie, you were talking about a couple of minutes ago, where, you know, there's this unknown DNA underneath the victim's fingernails. So, well, you know, signs of a struggle. Is the defendant the guilty one? Is it somebody else, or was it a group of people? It just raises a lot of questions.
And again, I was reading a lot about this and realized this, we're pretty early in the case, so I don't know what's going to come out. But there may be, in addition to everything else we're talking about, some issue with regards to the prosecution believing that the DNA lab got it wrong. And so that's going to be, if we talk about all the twists, you know, that we heard kind of the last time in like the Gasper case, you know, in terms of like not believing that they got it right with the methadone, there seems to be some chatter about that as well, which I think would just be amazing that they don't even trust in their DNA lab to get it right. So time will tell in terms of that.
Well, that's a mess. I mean, so what's the response then from the defense? Turn around and just say, you know, you don't even have anything. You've got so much reasonable doubt in here, you can't even trust your own test results.
Well, I think interestingly enough, the extent of the injuries, the amount of victims involved in this case, that there might have been more than one assailant. And who's to say that the defendant wasn't one of the people participating in this? I mean, the cell phone records certainly make out a circumstantial case for him being in the vicinity.
I hear
And
you.
he lied and said he was at home.
Well, correct. The problem with, there's going to be a problem though, and I'm sure if you have a good defense attorney, there's going to be some issues with cell site, because I don't know the area of which this happened, but cell site is not always reliable in certain areas, and so sometimes when someone thinks someone's close means like 2 blocks, sometimes close means 1.5 miles. I don't know how far he lives from there, so I think it'll be interesting to see how the expert with regards to the cell site comes in, because that may really impact how well the prosecution's case goes in.
Yeah, but it's definitely a problem that he put on the record that he was home at the time when this happened, and his cell phone is going off in another area, close to the vicinity.
Well, that might be the critical piece of evidence that we need to keep our eyes on as this thing continues. I want to continue listening to the testimony of the forensic examiner, talks a little bit more about the evidence collection procedures.
A moment. Did you collect some scrapings from Ms. Peters?
I did.
And what is a scraping?
I'm trying to think of how to explain it to males in a manicure way. It's basically just kind of a long wooden-like tube that's very flat on the ends, and it scrapes underneath your nails to get things from out in between your nails, and it's approximately that long. And we use it to get nail scrapings for any kind of evidentiary value.
Okay. And we noticed in some of the pictures that you showed us yesterday, and I think that you actually collected an acrylic nail from the scene, correct?
Yes, ma'am.
So did Ms. Peters have some acrylic nails?
Yes.
What is an acrylic nail?
I believe it's just kind of a fake nail that they glue on when you go to a manicurist and get your nails done. It's a nail that goes over your original nails that's longer.
Are those nails scraped underneath in the same way that someone who doesn't have acrylic nails, how you would scrape them?
Yes, yeah, we just go underneath any part of your nail, just trying to get into the nail bed to get any kind of evidentiary value that would have stayed in there.
All right, so I want to turn your attention to states 103, A through J. Actually, would you mind showing the jury what you're looking at there in your notebook?
It's a large compilation of evidence that I collected.
Okay, so each swab is inside like a plastic folder?
Yes, like a laminated section.
Okay, thank you. All right, so looking at states 103, A through J, please let me know if you recognize those items.
Yes, ma'am, I do.
And what are states 103, A through J?
These are all of the nail scrapings that I took of Brandy Peters. I took one individually for each of her fingers.
Okay, can you tell us, so you took a thumbnail, a fingernail, a middle nail, a ring nail, and a little nail from each hand?
Yes, ma'am.
And each of those are all reflected in states 103, A through J?
They are, yes.
At this time I would move, are they in the same or substantially the same condition as when you impounded them?
Yes, ma'am, they are.
This time I'd move 103, A through J into evidence.
Any objection? 103, A through J will be admitted.
Okay, at this time I want to turn your attention to 103, K through Q. Do you recognize K through Q?
Yes, ma'am, I do.
And what are K through Q?
These are swabs that I took of the hand area and neck area of Brandy Peters.
And how do you swab a deceased victim's hand and neck area?
The same way we collect a sterile swab of any kind of suspected blood on the wall, we still use the same sterile swab, and we use distilled water that's also sterilized in each collect a sample of each. So I'd put it on the Q-tip, and then for specifically her neck area, I would just swab along her neck.
And which areas of her neck and hands did you swab?
I believe it was the left side of her neck, the right side of her neck. I took the back of her hands and the palm areas of her hands.
Of both hands?
Yes, ma'am.
Okay. And what about 103Q? Where did you swab there?
I took a swab of her right earlobe.
Any specific reason why?
There was a darkish material on there. I wasn't able to determine what it was at the time, so I collected a swab of it.
Okay. And are 103K through Q in the same or substantially the same condition as when you impounded them?
Yes, ma'am, there.
At this time, I move K through Q into evidence.
Any objection?
Okay, so we're continuing our review of testimony up until this point in the Segura case in Florida, and an interesting case. And, you know, does the defense really try to get to the bottom of whose DNA it is, or does the defense just get in front of the jury and say, hey, look, there are way too many unanswered questions here to try to convict my particular client?
Yeah, I mean, just poke holes, find those questions that really beg answers that we're not going to get. And look, you know, there's different DNA. It's not my client's. There was clearly a struggle. As Julie pointed out, the nail was broken, DNA under the nail. It's a little bit of a leap to suggest that the DNA is the result of the struggle. It may not be, but, you know, certainly you got to poke those holes. And this guy confessing that, I mean, is a hole that you could drive a Mack truck through.
Yeah, I
You
mean,
agree?
well, it depends. So if you have a case where you know who the DNA is and the DNA is not your client, then you're going to go after the fact that it's someone else. If you don't have a determination of who the DNA is, but you know it's not your client, then you're going to obviously not be able to focus in on one particular perpetrator. Here you seem to have multiple perpetrators because you have the guy potentially confessing, plus you have another drug dealer whose DNA is in the house. So you have a plethora of ways to go as a defense attorney to poke these holes that we talk about in terms of creating reasonable doubt.
Yeah, okay, so, you know, does that necessarily mean that the defendant wasn't involved, though? Did they just not happen to catch his DNA in the right spot?
I think, you know, when Ken talks about, you know, like you can find the DNA here, you know, by the way, it is kind of surprising if you have a guy who's been with a woman for a lengthy period of time and has a relationship such that they have a child together that you're not going to find any DNA in the house, which is kind of the irony of it all. So the mere fact that you don't have his DNA doesn't mean that he wasn't involved in the case. However, you have, go ahead, yes.
Oh, I was just thinking about another case. I mean, look, this is the big issue in the Stephen Avery case as well. You know, everybody keeps saying, oh, well, her DNA wasn't in his trailer. And it's like, okay, well, that doesn't necessarily mean that she wasn't in his trailer. You know, I mean, a lot of times you find it, but sometimes you don't. I mean, I've heard of cases where they've done a DNA test on something found in a house, and it turns out that it's a guy who owned the house 50 years ago who's been dead for the last 20.
Sure.
You know, I mean, sometimes this stuff hangs around. Sometimes you can't catch it at all.
Right, I agree with you, except that you don't just have the DNA in this case. And again, I know I'm going too far ahead of ourselves because we haven't heard the evidence, but at least what we know, what we expect coming is that it's not just a weakness in their case regarding DNA. There's seems to be other things that are helping the defense along, and the DNA just is another supporter that maybe they don't have the right guy.
And it's very unusual. I mean, you've got a jailhouse snitch saying that the defendant confessed. Then you've got some other guy saying, no, it's me. This sounds like some sort of weird drug entity, competition
there's an
that's
allegation
going
Sure.
very strange and in weird directions, and almost like maybe someone's willing to take the fall so other people don't have to pay the price.
It's such a great point, and you know, I was going to say, you know, one of the things as a prosecutor we always said, and I'm not pointing at you, it's just my pen, I swear.
Bite that pen.
Is that a lot of times people tend to think that when a prosecutor uses a snitch to get a confession, usually people think that they don't have a strong case, and that's why they're going with the snitch. And that is kind of, you know, one of the kind of quiet things people say, because I don't like using a jailhouse informant. That means that I'm kind of desperate for evidence.
Yeah, their credibility is subject to impeachment on cross.
So.
Yeah, good points. Well, we'll continue listening to the testimony of Annie Williams, the latent print examiner. She did a lot of forensic examination in this case, and we'll be back with more analysis after this.
suspected blood areas are essentially, it's all over the jeans.
So all the discoloration that you see there?
Yes. All the sites here.
Your Honor, can I approach up and hold those up? Okay.
He's a little taller. He might be able to get him up a little higher for all the jurors to see. Now that Mr. Fuchs has him, if you could just start with the left leg there, or the leg closest to you.
It appears that all of the discoloration in this area can be attributed to what would be suspected blood.
And moving on to the next leg.
And then we have it all here, along the sides, through here, and down on her leg area as well, and the cup of the jeans.
And can you point out any suspected blood on the back of the jeans?
Yes, again, this is colored areas where she was laying. The bottoms of the jeans as well. You have it all along the top, on the pockets, and all along down the sides.
Okay, thank you. And I'd ask you to do the same thing with the tank top and the pink bra from States 103 EE.
And again, it's any of the discolored areas that you can see, it's essentially most of the bra. And you have a hole in the bra as well, and all along the straps, and it's also gone on the inside.
Okay. And you did collect a projectile from the chest cavity, correct?
Yes, ma'am, I did. On the yellow tank top as well, you can see there's several holes through it, but it's also, it was yellow, so I would say that any of the colors that you can clearly see where there's staining of the blood, all on the front, on the inside, and along the back as well.
Okay, thank you. And finally, just the pair of socks from States 103 DD.
The same with both the socks. This was a gray sock, so you can see the suspected blood areas on the bottoms of the feet here and on the side as well. Then the multicolored sock you can see on the side, on the bottom of the feet area, and on the other side as well.
Thank you.
Yeah.
Thank you, Mr. Fuchs.
And that was the tail end of testimony from the lady who collected so much of the forensic evidence in this case. And we've been back and forth about the evidence, the DNA, the broken fingernails, the cause of death. The medical examiner was on the stand this afternoon. And, you know, there's this accusation floating out there that there's a drug cartel involved in this. We haven't, at least I haven't seen that testimony on the stand yet, but that's floating out there as well. You know, that maybe the reason that this victim was killed was because of some $90,000 drug debt.
Look, $90,000 drug debt, I think it's fair assumption to make that she was not a casual user. She was probably involved in the illicit narcotics trade. And this is very strange stuff about someone coming forward and confessing and putting himself in that position and inculpating himself. It's very unusual.
Right. I think what we were talking about before is you kind of want to know, like, A, why is he incarcerated in the first place? What does he have to gain? Which is kind of, again, what we started to talk about before, which is kind of, is he covering for someone else? Is he covering for the defendant? Is the defendant involved in this drug trade? I mean, who knows? It's that's why I'm enjoying this case so much.
You have to have some serious love for someone to confess to a quadruple homicide, or someone's really got the squeeze on you.
So just to let people know also, because this plays into this, where things are going in this case, Kathy Russin has sent me a couple of messages because she's trying to track out the timeline here. And apparently the state is planning to rest next week on Wednesday. So they'll have about a 5-day trial, it sounds like here, maybe 6. They've got to have another evidentiary hearing on whether or not this testimony confession is going to come in from this other inmate. And apparently they're going to do that after the state rests. So it looks like that guy's going to be a defense witness. You know, they're the ones that want him on the stand so badly. That's not a surprise. A couple of other points here. Medical examiner said as many as 8 gunshot wounds on Brandy Peters. 4 bullets were recovered from the body. You know, overall 10 shots were fired. That's the expert opinion in this case. So, you know, we got into some of the jury questions here, and the jury was rightfully asking, okay, well, you know, how many cartridges does a revolver hold? And, well, typically 7. Okay, so if they're saying possibly 10 bullets were fired, what's going on with the number of
2 guns?
You know, that insinuation could be the next connection here.
Well, but if you potentially you'll be able to tell, at least from, you know, once I assume they'll have a ballistics expert that testifies as to kind of whether or not the ballistics evidence came from 1, 2, or even more guns. So hopefully those questions will be answered. One of the things some people will say about this case is, you know, when you have someone shot so many times and beaten to such a degree, people start to think, is this a case where it's a drug cartel, or is this someone angry at his girlfriend? You know, so, you know, because it starts to feel like kind of that anger, like crime of passion. And so some people may view it that way. I'm not saying they're
well,
right.
if that's the case, then how did the kids wind up dead? I mean, you've got the 3 kids. That sounds like a send a message kind of crime.
Well, I mean,
you know, one of the kids was the defendant's kid.
Who are you sending the message to? Since right,
and the other 2 aren't.
You might be right, but it also may be, you know, at the end of the day, because I don't think the kids were shot, I could be wrong. It might just be, I need to get rid of the witnesses to what I've done to their mom. And it might be that simple. I don't know.
Yeah, could be getting rid of the witnesses, could be sending a very strong message to possible other third parties that might owe $90,000 in drug money to someone.
Right.
Yeah, I mean, there are still a lot of questions to be answered here, so we're going to continue plowing through some of the previous testimony in the case. The next person we're going to listen to is Joanne Maltese, who works for the Tallahassee, Florida Police Department in forensics.
You, Ms. Dugan?
Thank you, Your Honor. Good morning, Ms. Maltese. Will you introduce yourself to our jury, please?
Joanne Maltese, last name spelling Maltese.
And where do you work?
Work at the Tallahassee Police Department.
What unit are you in over there?
I'm in the forensics department. I've worked for the police department for almost 26 years and in the forensics unit for 18 years.
And your main duty in the forensics unit, processing crime scenes?
Yeah, so documentation and evidence collection as well as latent print examination within the forensics unit.
Can you tell us a little bit about your education and experience to become part of the forensics unit?
During the 18 years in forensics, I've taken over 1,500 hours worth of classes to include crime scene reconstruction, photography, latent print examination, palm print examinations. I also teach basic recruits at Pat Thomas Law Enforcement Academy, as well as advanced crime scene at Pat Thomas Law Enforcement Academy.
I'm going to take you back to November 20th of 2010. Did you respond to 908 Saddle Creek Run that day?
Yes, I did.
And what was your role there that day?
I was there to assist the crime scene techs there and offer any advice or opinions, help them with anything that they needed.
Okay, so you weren't the person that was the main one processing, you were just kind of overseeing and helping?
Yes.
All right. I want to show you a couple of photos that were entered into evidence previously yesterday. Looking here at 70 EEE. What part of the home are we seeing here?
It's going to be outside the front door. The front door, if you look to the left of the photo, that is the front door, and it's part of the garage wall, the exterior garage wall and the walkway.
And is there actually a laser up there on the witness stand for you?
Yes.
Oh, great, thank you. If you could just point out to the jury
front door is on the left side of the photograph. And across the photograph itself is the garage door, or the garage wall.
When we look within the scales here, if we look closely, what do we see?
There is a scale that runs vertical and horizontal on the wall, as well as smaller 2-inch scales placed on that wall. And there's some Sharpie writing that was done to show direction.
What about all these tiny dots? What are those?
All the tiny dots are suspected.
Okay, want to talk a little bit more about the bullets found here. Apparently 10 shots fired. The gun that was claimed to have been used here is a .32 revolver. The gun itself holds, revolvers usually hold 5 to 7. That type of gun, they're saying, you know, closer to usually 7. But apparently all 10 bullets came from that type of gun. So they're saying that one weapon likely reloaded. So, you know, now you're talking about...
Or both assailants had the same type of
or
gun.
some same type of gun. I mean, it's possible. It's possible. I can tell that you're angling for that defense.
Well, I'm not.
you know.
I'm just saying, like, you know, the same type of ammo is used in a wide range of firearms. You know, it could be possible that there were 2 different assailants. It could be possible they had the same gun. Could be possible that one person reloaded.
But you can usually match ballistics, you know, shell casings to shell casings and bullets to bullets. And with a revolver, since I assume there's no shell casings left behind because it's a revolver, potentially the ballistics expert would be able to see if those bullets came from one gun or not. But we shall see in regards to that.
We will have to. So we'll continue listening to some more testimony here from the Henry Segura case. This is Caroline Wilder, who is one of the forensics examiners.
Would you introduce yourself to our jury, please?
I am Caroline Wilder, W-I-L-D-E-R.
And was your name Wilder back in 2010?
No, ma'am.
Okay, what was your name at that time?
My maiden name is Carpentieri, C-A-R-P-E-N-T-I-E-R-I.
Thank you. And what do you do, Ms. Wilder?
I'm a forensic specialist at the Tallahassee Police Department.
And how long have you been with forensics at TPD?
About 7.5 years.
Can you tell us a little bit about your education, your training, your experience that's led you to be with TPD for 7.5 years?
Yes, ma'am.
Okay.
I attended college at FSU, and at that time in 2006, for the summer, I interned with the TPD forensic unit, where I got a taste and realized this was the field that I wanted to be in. After I graduated Florida State in 2007, I went to the police academy and got my law enforcement standards. It's not a requirement for the field that I am currently in. I'm not a sworn law enforcement officer, but I got a very broad knowledge of general police work. I started in my current position in March 2010, and from there I got a lot of in-house training. It was a 6-month, very intensive program. And since then, I've been to many, many, many classes about crime scene reconstruction, latent print examination, and so forth.
Okay. I want to ask you about your role in this case on November 20th, 2010. On that day, that Saturday, did you respond to 908 Saddle Creek Run?
Yes, ma'am.
All right. And did you go back later days, too, to help process the scene as well?
Yes, ma'am.
Okay. Were you there? Were you there on Monday?
No, ma'am.
Okay. Were you there on Tuesday?
Yes, ma'am.
Okay, and that would be November 23rd.
Yes, ma'am.
And I want to turn your attention to a few photos of some items that you collected.
Yes, ma'am.
Right. And then 70 HHH. What do we see in this item? Your Honor, would you mind bringing it up to the right hand? What do we see in this photo?
This is a photograph of the carpet near the foyer area. You can see that there is the purple staining from the leucocrystal violet in that photograph.
70 III. This is an up close view of that.
Yes, ma'am. It's an up close of that. This is before I have marked any pieces of evidence. In the very center, you can see what was collected as a suspected artificial nail that had been broken off.
Okay, and it's right here in the center of the photo that I'm zooming in on.
Yes, ma'am.
Looking at 70 JJJ, was that the nail after you zoomed in on it and put the evidence marker?
Yes, ma'am.
Right, and did you actually collect that acrylic nail?
Yes, ma'am.
And do you see states 88 in front of you?
Yes, ma'am.
And that appears to be the same as when you impounded it in evidence?
Yes, ma'am. Just the only exception, I can see FDLE evidence tape on it, so it appears it's been there, but other than that, it's the same.
Okay. If you wouldn't mind just looking at the other items there on the witness stand that you also have in front of you, are those all items that you collected from the scene that day?
Yes, ma'am.
And they're labeling their packaging is the same as when you impounded it?
Yes, ma'am.
I'm going to show you what's been pre-marked as 70 KKK and entered into evidence. What do we see here?
The photograph that we're looking at is obviously it's of the floor. The front door is to the left of the photograph. You can see a little bit of the tile in the bottom left corner. There was an artificial tree that was in this area. It had been upturned, and so I was photographing sort of an overall view before I started closing in on items of evidence.
Okay. And 70 LLL.
This was more of a close-up of the tree. We have upturned it to its proper position and started examining the branches. In the middle of that photograph, you can see what we suspected to be a bullet hole.
There should be a laser up on the witness stand for you. You could point out to the jury where you see the indentation.
Yes, ma'am. Sorry. This right here is the suspected bullet hole that we observed in the tree.
Did you find any projectiles near the tree?
No, ma'am.
And in 70 MMM, did you mark that indentation with a evidence sticker or a scale?
Yes, ma'am.
What about in 70 NNN? What do we see here?
This right here is also on that tree. This was suspected blood that we observed on the trunk.
Did you take a swab of that blood?
Yes, ma'am.
And it's there on the witness stand in front of you today?
Yes.
It's marked as states 86?
Yes, ma'am.
All right, I want to show you 70000. What do we see here?
This is the front porch area where I was standing taking the photograph. The front door is directly to my left, so this is to the right of the front door on the wall. And you can see here that there are a couple of hairs or suspected hairs that were on that vinyl siding.
70 PPP and up close of the hairs?
Yes, ma'am.
And we see the scale there. Did you collect the hairs?
Yes, ma'am.
Okay, and that's what you just identified in front of you. That states 87?
Yes, ma'am.
All right, and 70 QQQ. What are we looking at in this photo?
This is the other side of the front porch. Now the front door is to the right from this view.
The front door is with your laser?
I apologize. The front door would be about here. You can see a little bit of the jamb right here. This right here would be the front door, and this is the front porch area to the left of the front door.
Did you find anything of evidentiary value on the front porch ground?
Yes, ma'am.
Okay. I want to show you this closer view 70RRR. Were you trying to get a closer shot of what you saw?
This is more of a mid-range photograph to show closer up of the evidence that was found on the porch.
Okay, and what was that evidence?
There was suspected blood on the ground.
Can you see where it is in this photo?
I believe, from my vantage point, I believe it's around here. I have it marked in a separate photograph.
Okay. 70SSS.
The suspected blood, obviously, right there.
Okay. And so this is on a portion of that photograph where it's actually in the shade of those, of that banister or railings, right?
Yes, ma'am.
And what did you do with this suspected blood?
I took a sterile swab of it.
Is this about where you were talking about?
It appears to be right in this shadow area, right there.
And the swab that you took of this drop of blood that was out on the front porch, is that there in front of you at States 94?
Yes, ma'am.
Did you collect a couple of items of evidence from inside the house as well, from different rooms?
Yes, ma'am.
All right, I want to turn your attention to States Exhibit 39B. What is 39B?
39B is miscellaneous paperwork from the Master Bedroom Entertainment Center.
Okay. And did you collect some items from the kitchen as well?
Yes, ma'am.
And what are the items from the kitchen?
Well, in front of me, States Exhibit, I believe that's 110. Miscellaneous paperwork from the kitchen drawer, which was the southernmost drawer near the trash can.
Okay, I think that would be 100. I just have poor handwriting.
Oh, I apologize.
And
States
101?
101 are trash bags from the cabinet above the drawer.
And are those all the items that you collected from the home that day?
I believe so.
I want to ask you about a few more photos. These have been entered into evidence of by stipulation as 130A through P. In 130A, is this kind of just an overview of the foyer once the reagent was applied?
Yes, ma'am.
All right, I want to ask you about some photos that you took of different marks that you saw in the reagent. Is 130B one of those photos of you trying to capture any marks you saw?
Yes, there was what we suspected could have been shoe impressions in there, and I wanted to make sure that anything that I saw that could be potentially used as evidence that I photographed.
Okay. And looking at both of these photos, are a lot of the photos that you take around in this area around where we see most of the purple to the right of the door as you walk in and leading into the living room?
I know I took photographs in that area. I can't recall specifically where the impressions were in these photographs.
Okay. I want to specifically show you some on the tile 130C. Are these some of the marks that you photographed on the tile that you thought maybe could possibly be used for something?
Yes, ma'am.
Okay. 130D.
Yes, ma'am.
Did y'all apply any chemicals, looking at 130E, any chemicals to try to help these show up more in any areas of the home?
Well, in this area, you can see that there is the purple stain, which is the leucocrystal violet.
In the bathroom?
In the bathroom, I didn't use chemicals to try to enhance any type of shoe wear. Instead of using chemicals such as this, I used powder to try to, regular fingerprint powder to try to enhance any impressions that might be on that bathroom tile.
Okay. And looking at 130G, did you also try to measure these as much as you could?
Well, I didn't specifically note any measurements, but I take the photographs with a scale. So if they need or could be used later, then this size can be accurately represented.
And these are the photos where you tried to get any pattern with the scale.
Yes, ma'am.
Okay, and you took these photos after the home was cleared.
Okay, welcome back, folks. We're continuing to review testimony in the Segura case, and for a case with a lot of really fascinating twists and turns that we've been talking about, the testimony just doesn't really energize me. Sorry, but you know, I'm waiting for the real interesting stuff to come out of this case.
And I understand that, and that's the dilemma for every single prosecutor is this stuff has to come out. They must present it to the jury. They have no choice. Usually what we try to do is beforehand, when I was a prosecutor, say, listen, there's going to be stuff you're going to be kind of bored by, but you need to kind of pay attention because you're going to realize how meaningful it's going to be at the end. And so, but yeah, it is painful. It's also, quite honestly, usually painful for the prosecutor because they have to go through hundreds of pieces of evidence that they have looked at and talked about before. And so imagine from their standpoint, it's exhausting. So
It's very exhausting for the defense to watch this. But look, building a case is like building a house. You have to start with the foundation, and you go from there.
Now, I was wondering, Ken, if you would say, hey, if you were to make that argument, Julie, and say, hey, you know, there's some parts that'll be less than exciting, do you just turn around as a defense attorney, Ken, and say, I'd prefer that you just not pay attention to those parts? I know you don't, but...
No, I mean, look, there are certain things that are a given that are going to come in. You know, the sky is blue. It was raining that day. Whatever it may be, there are facts that are just undisputed that come into trial. Defense attorney's job is to really poke holes in the prosecution's narrative and inject reasonable doubt, or at least shine the light on those places where reasonable doubt might be hiding.
yeah. No, I was going to say it's the prosecutor's job on opening to get the jury kind of excited for buzzwords. So be able to say to the jury, listen, you might not find it exciting, but listen for the word .32 caliber gun. Listen to what the ballistics expert has to tell you. So I want you listening for them because then the jury actually is working with you to try to get through each piece of evidence. And then when you're summing, you're kind of wrapping it all up for them. And so they're kind of with you from beginning to end. And that's how you kind of get the jury invested and engaged in this case.
Yeah, I mean, part of me feels that I've been cheated out of life. I have not had the pleasure to see Julie Rendelman try a case when she was a prosecutor.
I can't believe that you actually feel you've been cheated out of life. I need to write that down and put that up in my
Look,
room.
I wanted after weeks of animosity, I wanted to pay you at least one backhanded
Completely
compliment, whatever you
backhanded.
want to talk about. So,
No.
well, let's continue listening to the testimony in this case. We've got some stuff queued up from the medical examiner who was on the stand earlier today. She's testifying without the jury present. She gets into some details. Eventually, the jury comes back in at the end of this, but this is outside the presence of the jury.
State your name for the record, please, ma'am.
Lisa Flanagan, that's Flanagan.
Have you provided her with photos you're proposed to use, Ms. Stevens?
Yes, sir. I don't know which specific ones that
We'll give them all to her.
Do you want me to identify for you ahead of time which ones?
That would be good.
With respect to the autopsy photos of victim Brandy Peters, this states 102. It would be D, E, G, I, O through T, W, Y, J through LL, VV through WW, and AAA and BBB.
Triple A's.
Yes. With respect to Maya Peters, I didn't mark the initial photo identifying her, but I don't object to a photo to identify who it is. But then after that, the only ones I don't object to are I, J, O, Q, and R. The rest I would object to.
those are 102 and 104. Were there objections? There was 106 and 108. One of those is Tanaya and one of those is Javante.
Yes, Your Honor, I object to all of those autopsy photos.
And that's just a generalized objection. Don't think we should get into them because you're not disputing the cause of death.
Yes, sir, 403 analysis.
Okay. All right. Dr. Flanagan, the prosecutors indicated that the photos that she is marked for identification to be presented to the jury are photos that you picked out to explain your findings. Is that accurate?
Yes, it is.
There is an objection as to some of these photos based upon them being overly gruesome, I guess. I guess that'd be the only way to describe it. Are there photos in there that you feel like you could do without that would not interfere with your ability to explain each of your findings in the case? In other words, are there repetitious photos in there?
I tried not to put repetitious photos in there. I went through and picked out the photographs that were as clean as the ones that I have, the ones where I've cleaned the blood off. But she has many, many injuries, and the photographs show different angles, and basically I tried not to duplicate them, but yes, some injuries show up in more than one photograph, but that's because I had to show different angles to get a better view of the wound that I was trying to document.
You want to cross on that, Mr. Prince?
I suppose it would be most helpful to have the photo so I could ask her specifically why that photo is necessary to explain her testimony and findings. Or do you want me to just inquire generally?
We're not going to go through
Yes,
each
sir.
photo
Okay.
at this point.
With respect to victim Brandy Peters first, the photos that I'm most concerned with are the ones of internal examination where you're tracking bullet paths and things of that nature. You can't really, would you agree that you can't really tell as a layperson what you're looking at there anyway? Could you explain verbally to the jury without having to show them internal pictures of the victim in an effective and clear manner without showing those pictures?
Well, I think the photographs, the ones you're talking about with the probe through them, show the wound tracks through her body. They're the only ones that actually, as far as the gunshot wounds, caused injury to an internal organ. I didn't show any pictures of the organ itself, but kind of implying this is where the lung would be, and I just show the path that it took through that chest. And they're the only gunshot wound injuries that, as I said, caused any significant internal trauma.
I mean, you're going to verbally explain all that to the jury as well as you're showing pictures, correct? That's your plan?
Yes.
Could you explain just as effectively what the path is by simply saying, look, the bullet entered here on the left side of the victim's torso and exited there on the right side of the victim's back? Can you do that in a manner that is clear, as you did in your report?
I mean, I could try, but obviously I'm not able to know how they're interpreting that and if it would help them visually to see the wound track through her body.
With respect then to the wound, the primary wound to the victim's forehead on the left side, that's really the only specific individual wound that I have great concern about. Could you explain that wound and how it led to the victim's death without having to show pictures of that wound?
Well, that particular wound is probably the most significant wound of all that she sustained. It's probably the fatal wound.
Could you just say that and let the jury know that there was a significant injury to the left side of her forehead with skull fractures and breaks and all that caused brain hemorrhage? Could you just explain it like that without having to show that part of the pictures?
Again, I can't tell what they would interpret from my words when there's a photograph to show it. Even her identification photograph will show the injury to to her face.
I understand. I would just make argument, Your Honor.
No, you can be heard.
All of this is subject to a 403 analysis. Clearly, it would be, in the witness's opinion, useful to be able to explain with photos so that they can see exactly what she's talking about, but that's not the end of the analysis under 403. And I would suggest that it's not especially probative or helpful. The topics that she's talking about, bullet track or the injury to the forehead, are not hard to understand topics. She can say where the bullet entered and where the bullet exited. She can explain that the injury to the forehead was the primary cause of death. She can explain that there was skull fracture and brain hemorrhage. I don't think that the jury needs to see the victim's face caved in up close to be able to understand that, especially when cause of death is not at all in dispute, which goes to the first part of the analysis as to whether it's even probative. So given that the testimony is not in dispute and given that the pictures are horrifying, I would suggest that it's
All right, let's switch gears a little bit, folks, and talk about the Joshua Gasper case out of Cleveland, because we've been following that as well. Interesting case there. We've been trying to figure out exactly how the vehicles were all positioned, and we had one of the witnesses over the last couple of days sort of, explain this all, and it sounds like the car that the defendant was swerving to avoid was the car that the trooper was pointing at and saying, you have to pull over.
Right.
So that's why the car slammed on the brakes ahead of him.
Well,
I mean, I don't know if that necessarily makes it excusable to all of a sudden jerk over in the other lane. I mean, the proper response would have been to monitor the car in front of you and slow down.
The whole issue we talked about from the beginning was, and the question I always asked was, where was the car that the officer had initially pulled over? If the car was still in the lane, to me, the act of him not being able to stop in time while negligent did not rise to any level of some kind of criminal conduct. If the car that the officer had pulled over had been already pulled over to what they called the berm, and he still somehow swerved, I don't know why he would have been swerving, because the car wouldn't have been in his way.
Yeah, he looks like he swerved because the car in front of him, he said, slammed on the brakes. That's what the facts have been discussed for quite some time. And the reason that the car was slamming on the brakes is because the officer was pointing at it and telling it to pull over. And that's the way they do speed traps in a lot of states. The officer doesn't sit in the car and do it. They stand outside and then he'll point at you if you get caught, and that means you have to pull over.
Yeah,
that's what I'm taking away from
that whole
this.
policy needs to be revisited, but I don't know that the officer's contributory negligence is really defense in this jurisdiction. But I think it's really going to come down to is if they can establish through expert testimony that methadone really impairs motor function and the ability to operate a motor vehicle, which a lot of the scientific research, at least the research done in the United States, which happens to be using methadone to treat people afflicted by the opioid crisis, says that it doesn't affect motor function.
But part of the proof of that methadone is impacting him is the accident itself. And if you can't show that the acts by him swerving to avoid that person rises to the level of reckless just in and of itself, that impacts whether or not methadone had a role in any way, shape, or form in what happened. Because quite honestly, if you're driving in a car at a high rate of speed, even a little bit over the speed limit, which we assume the guy in front of him was since he was stopped before him,
yeah,
that when you stop, you're either going to hit the car in front of you, you're going to hit them, or you're going to swerve to avoid them. So you're going to swerve to the left or you're going to swerve to the right. The fact that he chose to swerve to the left, to me, does not rise, methadone or not, to the level of some type of criminal negligence, unless I'm missing something.
I don't think you are. I mean, and I think, look, I'm not buying the prosecution's case in this. I don't like the fact that they keep changing the speed that they think he was going. Okay, why wasn't that figured out long before now? And I know we talked about this a little bit before, and you said, well, things change. Okay, well, that's a little bit more of a scientifically concluded estimate than a witness who freaks out at the last minute and decides not to testify. So look, the burden's on the state. They should have had their act together with that long before now. And the fact that they didn't tells me that they were stretching to try to make the guy look bad when it got smeared all over the place locally that he was going 78 and a 60. If now they're saying, which is what they're saying, that he was going 62 to 65, that's a big difference. You know, and I've watched this go down in the Stephen Avery case, okay, where one set of facts comes out of the prosecutor and then half of them don't get proven at trial. So I have to turn it on and say, what's really going on underneath the covers here?
And let's be clear, the burden is always on the state to prove their case. The defense merely has to find the reasonable doubt. But look, you know, the fact juries don't like when a narrative changes. They don't like when someone's story changes. That's indicative, and common sense tells you it's indicative that something is not adding up, that they're being misled.
Right, well, prosecutors don't like it either. And, you know, you're up there, you give an opening
Always
statement.
the prosecutor.
But no, but think about it. You know, you're opening on your case. You say he's driving 78 miles per hour,
Yeah,
and then
you wanna
all of a
deliver
sudden
on
you
that.
you have an expert that gets up that totally undercuts what you're saying. It means either you're not prepared or the expert is somehow, you know, coming out with something that no one's ever heard, and there was no way you would have heard it. But at the end of the day, the case seemed to have fallen apart.
Yeah, and look, we've got all this evidence. Okay, they upped his dose within 7 days of when the thing happened, but the previous dose was at least the day before. It peaks somewhere between 2 and 4 hours in your system. You know, it's like if I had a glass of wine yesterday and got in a car accident today, then like that's already out of my system, you know? I mean, and the evidence is that it takes that long to peak. So this whole thing like, oh, he got in the accident 14 minutes after he took it. Well, it doesn't really even take effect until about, well, longer than 14 minutes, and it peaks 2 to 4 hours later after the dose. So, you know, somebody just jumped in the chat room and said the state is grasping at straws. Okay, look, I'll just use that to summarize my point.
While I agree with you, I do think, in theory, the presentation of that evidence, when they put that doctor, you know, the one with the purple bow tie, who I was mocking a little bit off camera, purple on purple is not a good look, but hey.
Well, now I know what to get you for Christmas.
He testified that he has over 600 patients. He really didn't have much an idea of what's going on with any of his patients. You know, there's the prosecution, I think, was effective at dismantling him a little bit.
I don't know if I don't know if I fully saw it that way. I mean, I didn't watch all.
You think purple on purple is good?
I think purple on purple is really, really, really good, and I think that that's what we should be focused on. No, but I think he did a better job than you're describing. But I think one of the things that goes along with kind of the mess of this case is this isn't a person who just went home and sniffed cocaine and got in a car. This is a person that was prescribed a drug by a doctor moments before he got in a car.
To try to deal with an addiction that was the result of other drugs that were prescribed by doctors.
And so in a jury's mind, if I'm the jury, I'm going to say, well, what the heck is the doctor letting him walk out the door if the doctor thinks something's wrong with him? And if the doctor doesn't think that he's under the influence, then why should we?
Well, hold on. We have a huge opioid crisis in this country, and a lot of the drugs that are affecting people and their motor function, it's legally prescribed drugs. Now look, I get it. They say methadone doesn't impair motor function. Now methadone was created to get people off of heroin, which was created to get people off of morphine. Do you see a pattern forming? At some point, we may learn that methadone might have some serious deleterious effects. I think that methadone really is the co-defendant in this case.
They've done a lot of studies though.
A lot of studies done in the United States. Studies being done in Europe, which does not typically prescribe methadone as well. Those studies are reaching different conclusions.
Yeah, I mean, when we look at the facts of this case specifically, keep in mind we have a guy who doesn't seem to be showing any signs that he's, under the influence of anything.
The sergeant testified that he was, but look, I agree. I don't think that.
By the way, we could go back and forth about the sergeant. The sergeant didn't offer much. He offered that he had, his opinion was different on every single case he's ever handled, and that he was wrong 3 times already with other cases of which individuals were acquitted because of the mistakes he made.
Well, that's right for cross-examination, certainly.
Yeah, I mean, I'm really looking forward to the way they're going to do the closing arguments in this case. That's coming up next week, but for now, we're going to wrap things up for the day. So Ken Belkin, criminal defense attorney, Julie Rendelman, criminal defense attorney, former prosecutor, LawNewz trial analyst. Nice to have a good depth of opinions here around the table today.
Always good to see you. Have a great weekend.
Thanks for having me.
All right, we'll be back on Monday at 8:30 this time because the Segura case in Florida has an early start time. The judge is telling the jury to make sure they're ready to go at 8:30, so we will be here a little bit early for you on Monday. And of course, we do stay late if testimony requires it. For now, though, this is Aaron Keller at the LawNewz Network. Thanks a lot for joining us this week, and we'll see you back Monday morning.